When my dad was sick, I remember sitting in the hospital talking to the doctor. And that doctor said to me, the most important thing for a person's recovery is whether or not they have an advocate. And I said, what does that mean? They need somebody that's going to show up on a regular basis, listen to what the doctors are saying, talk to the nurses, ask questions about medication being given. Really just somebody that can be there and talk on your behalf. And that's what you're choosing when you choose this person in your healthcare power of attorney.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. I'm attorney John Sauter, the senior estate planning attorney at Cordell & Cordell. Joe Cordell is not here with us today, and I'm going to be talking to you about powers of attorney. I talked to you in a previous episode about financial powers of attorney. I explained in that episode that there's two major types of powers of attorney, one for your finances and the other for your health care. Today, we're going to talk about decisions that come up in relation to your health care and how a power of attorney can help you make those decisions. So the first thing I want to talk about with healthcare powers of attorney is the fact that when we create a healthcare power of attorney, we're going to create 3 documents for you, okay? The first one is just called a healthcare power of attorney. Similarly, when we talked about financial powers of attorney, this is building an agency relationship, okay? You're going to name someone to act on your behalf when you can't. And with the healthcare power of attorney, the decisions they're going to make on your behalf are those related to your healthcare, your body, okay? Decisions that you normally would have made yourself, but you can't because of whatever reason that may be. You're medically unable to, most likely, okay? And so those 3 documents that we're going to talk about today, the healthcare power of attorney, the HIPAA release, HIPAA, okay, and the living will or medical directive. And these documents all work together to put a plan in place, and they all have different functions and features, okay? The first one being that healthcare power of attorney, who's going to make decisions when I can't? The second is that HIPAA release. Who can access my healthcare information, right? Different. Just having that HIPAA release with somebody named on it doesn't mean they can make decisions. It just means they can talk to your doctor or your nurse and review charts and learn about what's going on with your situation. The third document is a living will or medical directive. This is when you give specific direction to your healthcare practitioners about what you want done at end of life, okay? And so they all work together because they're all talking about the same thing. What kind of treatment am I going to have, and should I have it? Okay. And generally during your life, you're going to be the one making these decisions. But we're going to put this in place in case you can't be the one making the decision. And so similarly to the financial power of attorney, who am I going to pick, right? Well, first off, I want somebody that has some compassion. That's the healthcare power of attorney, and an immediate difference to finances. If you're going to be managing my finances, your compassion isn't as important. But if you're going to be making decisions about what happens in my medical treatment, I want you to care a lot about what's going on. This is a lot of times when I'm in a meeting with someone, they'll say, oh, yeah, we don't want the same person. We want the nurse in the family to be the one that does the medical power of attorney. Great. What kind of decisions are they going to make? Well, generally, they're going to make any decision that you could have made. So if the doctor says, do you want to do a certain procedure? How about some certain type of medication? If you can't make the decision, they'll decide, okay? But it also includes heavier decisions. What happens at end of life? Who can decide whether nutrition and hydration is removed, okay? And so this gets deeper than some of the financial stuff does. And here you really want to have a relationship with this person that you're going to choose as an agent, that they understand what you would have done in that situation, okay? And sometimes people just know you that well, and it's an easy pick. A lot of times you've got to communicate with them. Well, I have this certain religion, or I do this certain thing, and I really prefer. One of the decisions that they could make is palliative care. What kind of drugs or procedures would you want done to give you comfort when things are difficult, okay? Generally what we're talking about is opiates or morphine. Is that something that you would want administered if it would give you comfort, okay? The healthcare power of attorney is going to be making that decision for you, and so that needs to be communicated to them. We're going to handle a lot of it. Similarly to the other documents we've talked about on Life's Third Act, we're going to sit down and walk through it, okay? So first we're going to walk through, who do you want to act? As I've said before, I'm not always a fan of picking multiple people. I think that it's best to have one person that can make decisions on your behalf. However, a healthcare power of attorney, I'm going to give you a little bit more latitude, right? Because with a financial power of attorney, there's usually not as much of an emergency, right? Usually the bill doesn't need to be paid in the next 3 minutes. Sometimes decisions in healthcare need to be made quickly. And if somebody's unavailable, who can act? So in many situations, especially with kids, I'll name both parents, okay? And either can act.
That brings up an interesting question. Like, I barely answer my phone anymore because of all the spam phone calls that I get. So, like, let's say the hospital, like, they're calling from the hospital and someone doesn't recognize a number. Mm-hmm. And you're just going to have to go down that list until you can find someone that can immediately give you that decision.
That's right. There is some urgency and immediacy in the healthcare power of attorney. Now, granted, hospitals, doctors, they've been dealing with these problems for years, right? So they have their own protocol on who can make a decision. They're not going to let you linger because they can't reach somebody, right?
Of course, then you got the health insurance companies, too, that factor into this greatly as well.
Yes, very often when I'm talking about estate planning, I'm talking about the people in the room. And I'll always joke and say, okay, it's you two and Uncle Sam, right? Because every decision you make might have a tax consequence, and you always got to think about it. And you're right. In the healthcare world, we've got the practitioners, but we also have the insurance companies, right? Are they going to approve it? And so when we're looking at the decisions we're going to make, we've got to think about all those factors. And so just because that person can't serve doesn't mean your plan's going to fail. But you want to make sure that they're aware that they're going to serve in this role. Okay. And so when you come to Cordell and we put together a plan for you, we're going to give you a binder that's going to have all your documents in it. It's also going to have some documents that will help you get organized. And the first one is the checklist, right? And we talk about, how do we make sure all of my assets go where I want them to? How do we make sure that people know about what's going on? But one of the most important steps on that checklist is communicating to your agents. If we put these documents in place, you put them in the binder and you put them on a shelf in your office and never touch them again and nobody knows about them, what are the chances they're going to work, right? And so we're going to give you a binder with all the originals, but we're also going to give you a little USB drive that's going to have the digital documents on it. And in many situations, if you're comfortable, I recommend sending those to the people that are going to have to serve on your behalf. One, that allows them to have them in place if they need to act on them. Two, it gives them a chance to ask questions, right? And when you're incapacitated, they can't ask you why you did it. But if during your capacity, shortly after you've done it and you've met with me, they say, well, what does this even mean? Hopefully you can explain it. If you can't, you can still lean back on me and say, hey, John, they sent me this question. I don't really know the answer. Can you help me explain to them what this means? Okay. I would rather figure those things out when it's not an emergency situation, right? So it's important to communicate and let these people know what your plan is.
I'm glad you brought that up because I'm sure there's a lot of people out there that are like, okay, I wrote all my information down and I put it in this place in my house. Mm-hmm. How does anyone know it's there?
It is. That's true.
But if you spread the wealth,
yeah,
the chances of someone finding those documents is a lot higher.
Yeah, there's an awkward moment in some meetings where I'm talking to people about this stuff and they'll say, well, we've got a safe at home. We'll put it in the safe, right? And then I ask the next question. Can you guess what the next question is, Justin?
Who has the combination of the safe?
Who knows how to get into that safe? Oh, well, I know the combination. Well, that's not going to help us, right? We want to make sure that people know how to get in there. And if that's the point where you say, well, I don't really trust them with that, then let's pick someone else, right? Because we've got to trust somebody to make these decisions on our behalf. And if they don't know how to access the documents, they're already handicapped in trying to help you the way that you need to be helped. And so when we're looking at that healthcare power of attorney, if you could make the decision, you'll be able to, okay? But if for some reason you can't, or what you would say can't be trusted because of what's going on with you medically, we're going to lean on this healthcare power of attorney to make these decisions. And what kind of decisions can they make? Well, we've talked about what procedures are done, but on a bigger picture, they could talk about where you're going to get your care, okay? I don't know if you've been in this situation before, but when you go to get care for someone and it's an emergency, a lot of times you end up at the closest location, right? Does that mean that that's the best level of care that person could get? No, it's just where the ambulance took us, okay? And sometimes you can't pause. But if you can, I always recommend stopping and thinking, am I getting the best care I can get in this institution? Is this the best institution to address the care that I need, okay? And I talked to a cancer doctor about this one time, and he said, John, it's amazing how much of an outcome is determined by who you end up in front of. If you just roll the dice, you get what you get. But if you do a little research, if you call around, if you use your resources, if you've got friends and you think, oh, you know what? Actually, my friend's a nurse at this cancer hospital. I'm going to call her and say, this is what's going on with me. Who should I see? I think it's a very wise decision. And if you're going to have an agent, you're going to want somebody that's going to think along those same lines, right? Okay, doc, what's going on? Is this, you can ask them, is this the best place to get this done? Okay. Most of these doctors aren't working on commission. They should be able to help you. That's their job, right? They've taken an oath to try and get you the best care. And so I'd start right there and go, okay, how many times have you done this procedure, right? It's like when you're getting your car worked on, sometimes you want a second opinion. A lot of times with your treatment, you do, right? And as long as there's not an emergency, I'd highly recommend it. And so with this power of attorney, that agent can make sure that you're in the right place getting the right treatment. And if you're in a place, right, that isn't giving you the treatment that you need, they can remove you. They can end that relationship with that institution and put you somewhere else. Or, another thing that scares people, if you're going to stay at home and you've got an in-house caretaker, okay? I don't know if people have seen the movie Misery. That might be a little old one, but that scared me for a long time about in-home caretakers. If you get in a situation where they're taking advantage of them, having that person to make decisions on your behalf and be able to say, you know what? You're not coming back anymore. We're going to hire somebody else, right? I want somebody to be able to do that. When my dad was sick, I remember sitting in the hospital talking to the doctor. And that doctor said to me, the most important thing for a person's recovery is whether or not they have an advocate. And I said, what does that mean? They need somebody that's going to show up on a regular basis, listen to what the doctors are saying, talk to the nurses, ask questions about medication being given. Really just somebody that can be there and talk on your behalf. And that's what you're choosing when you choose this person in your healthcare power of attorney. Similar to the financial, you don't have to know the future, right? And so that's why we recommend you list multiple people. Maybe your first choice, but also I want to hear your second and your third, okay? Another thing with people with kids, right? We're going to draw up these documents, and I meet with a lot of people, and they've got 3 kids that are 8, 5, and 3. They would never think of naming those children in the power of attorney, right? Well, when I'm writing this document, I am writing them for what could happen tomorrow, but I'm also writing them for what could happen in 10, 20, 30 years. And while the person that's going to make that decision for you tomorrow might be your sibling or your aunt or your uncle or your parent, in 20, 30 years, it's most likely going to be that kid. And so I'll name the aunt, uncle, sibling, and then in succession, those 3 kids, right? And so we've put a plan in place that will survive no matter what happens. And that's the way I'm thinking when we're talking about this.
Are there ever time frames, like at this time, this person kicks in, or is it just literally going down the list?
You can be specific like that. I tell people general is better because when I'm giving instructions in the future, I don't know what's going on. And so if I say this person, but only in this situation, I might have foreclosed other opportunities, right?
Sometimes being too specific can hinder you.
Sometimes being too specific can hinder you. But I've definitely, I say on here a lot, if you can think it up, I can write it. And a lot of times this will come up with in-laws, okay? Now, my first rule of thumb when I'm doing estate planning, no in-laws, okay? I know it sounds harsh, but, it's we are a divorce firm, and so we're very aware of how those relationships end. Fortunately or unfortunately, blood relationships don't end. And so when you're naming your heirs and agents and people that are going to act on your behalf, most of the time, we're going to name a blood relative, okay? There are instances where the most capable person is an in-law, right? Oh, my nephew or my son-in-law, Jerry, is a financial advisor. Who else would I rather have do it? Not divorced from your daughter, Jerry, okay? And so right now it makes the most sense. I've written in Jerry as long as he is still married to Becky, right? And so you can put some of those that are going to exclude people under certain circumstances, but a lot of other times you want to say, oh, well, if it's going to be this situation, I want this person. If it's going to be this situation, I want this person. Quit being so controlling, okay? Let's give them the best opportunity to make the decision in the future. And when you're trying to make them now, you're making it so they can't make the best decision. Another big thing that comes up with a healthcare power of attorney is next of kin, okay? This is who can make decisions about what happens with a person's body after they pass, okay? Will they be cremated? Will they be buried? Will there be a ceremony? The law addresses who can make those decisions. If you get a power of attorney, again, like a lot of the other documents, you're taking the power back from the courts. You're deciding, okay? And so if you say in this document that your child is going to be your power of attorney, they will also be able to make a decision about what happens with your body, all right? In Missouri, we call this the right of sepulture, another state-specific thing. Who can make the decision about what happens, right? So the first thing you've got to do with the next of kin is communicate with them. What do you want done? Do you want a big ceremony? Do you not want people around at this time? Do you want to be buried? Is there religious ceremonies that you want to follow? All these things should be communicated to this individual and that person. It's the only thing that survives under the power of attorney. Generally, a power of attorney will end upon your passing, okay? The only thing that survives it is two things: the ability to make decisions about what happens with the body and to be able to make decisions about organ donation. And that's another thing that will be covered in your power of attorney. Are you an organ donor? And here's where I will let you get specific, okay?
Which organs?
Which organs is one thing. Sometimes you don't think about this. Justin, do you know what the most donated organ is?
Oh, that's a great question. Lungs.
Skin.
Oh, I would not have even thought
Most
of that.
people would never think of that. And it's because of all of the skin transplants, right? Anytime there's a burn, there's a grafting, right? That a lot of that skin can come from, if you don't have enough yourself, from a cadaver. So skin is one of the biggest transplanted organs. Sometimes you don't even think about that being an organ, right?
So if you sign your organ donor card on the back of your driver's license, does that include skin too?
If you sign the organ donor card on the back of your driver's license, that includes everything, right? This is where the power of attorney comes in place. So practically speaking, they're going to look at your driver's license to determine whether you're an organ donor. But remember that individual in the power of attorney has the right over your body. So they could restrict what is given, okay? And if you write in your power of attorney for any purpose, right? If they want to do whatever they want with it, they can donate it, they can study my body, they can, do whatever they want to do, or you could limit that. I don't want to donate my skin.
There's no open casket if you don't have skin.
A lot of times the circumstances dictate that. And these funeral homes are pretty amazing about what they can do. They're talented individuals. For every skill, there's an individual that can do it, right? But they can make you look pretty good. So in addition to making decisions while you're alive, the healthcare power of attorney will make some limited decisions when you're gone. Speaking of when you're gone, end of life is a big discussion here. You need to be able to talk to this person about what you would want done. And what I'm thinking about here is end of life decisions. When your quality of life has diminished, okay, you could be alive but not have the quality that you did before. Well, like a coma, a persistent vegetative state, significant and irreversible brain damage. In these circumstances, your quality of life could be diminished. And whether or not you want additional procedures done that would sustain you and keep you alive is your personal decision, okay? And you've got a couple options with these documents. First, you can just name it in the healthcare power of attorney. This person can make this decision for me, and whatever they decide, I will honor. Obviously, you can't say anything, but whatever they decide is what you would have wanted. But you can also be specific, and you can do a healthcare directive. In Missouri, the original one that we came up with was the living will. And that's a statutory document that says, if I'm terminal, any procedures that would only prolong my death, I don't want done, okay? This is the pulling the plug is what most people would refer to this as. But terminal is very specific, right? That means you're going to pass imminently. And in Missouri specifically, that was a problem. There was a case back in the 80s with Nancy Cruzan. She was a 25-year-old woman who got in a car accident, and she had brain damage. She ended up in a persistent vegetative state. Shortly after the accident, they asked her husband, because she was married, can we put in a feeding tube? He said, of course, right? Let's do everything we can to get her the treatment she needs to get better. Well, the feeding tube worked, and for months and months she persisted, but nothing changed. And then it became clear nothing is going to change. She's in this persistent vegetative state. And at that point, the husband talked to the parents. They agreed, we would like to pull that feeding tube out. The hospital said, no. We have no direction from her on what you'd want done, and there is no power of attorney, right? This is when those hospital rules fail of next of kin because they've got their own liability, right? And this is when the insurance company and the attorneys show up in the room thinking about, okay, if we pull the plug here and somebody disagrees, what happens, right? So if there's no clear direction, we're going to default to no action, all right? Well, this upset the family, and so they took them to court, and the Missouri Supreme Court sided with the hospital. They said the hospital's right to preserve life is greater than the husband or the parent's right to end it. And that may or may not make sense to you, but it doesn't give a lot of options if somebody hasn't done any planning, right? Or what kind of planning could they have done? And so that's when it went to the United States Supreme Court at the federal level. And they said, wow, this is a horrible situation. There should be the ability for people to say what they want done in these circumstances, right? Above and beyond what the state statute says. And so what we do now is we call a medical directive on top of that living will. So the living will addresses if you're terminal. The medical directive addresses if you're in a state where you're not necessarily terminal, but your quality of life is reduced so much that you may not want to persist, okay? And we're not talking about assisted suicide here. We're talking about the choice of doing additional procedures, okay? So let's say that you're in a coma and you've been in that coma for a couple months and they discover a cancerous tumor in your arm, right? Would you want them to operate on you? Because they're going to, right? Let's remember that healthcare practitioners are trained to treat, okay? And that's their job. And so if they've discovered an ailment, they're going to treat it. We don't always want to be treated. Sometimes I would rather just pass naturally, okay? And if you get to a position that the only thing that's keeping you alive is machines, you might have an opinion on what you want done then, right? And I'm going to respect your opinion regardless of what it is. We have lots of people that say, you know what, John, I'd rather not persist. I'm going to sign this medical directive, and I'm going to say that all of these different procedures don't need to be done unless they're going to improve my condition, right? There's a whole nother camp of people that would rather stay alive no matter what. Okay. Put me next to Disney, freeze me. And if everything can get fixed later in the future, you can thaw me out and bring me back. Right. Probably not the predominant opinion, but we can write for that. Most likely, most people's fear is persisting in a state that isn't their quality of life they're used to. And so we've got a document we can sign that will do that. And then we'll talk directly to the doctors and tell them, under these circumstances, I want this treatment done. Okay. Now, remember, your healthcare power of attorney has that right already. This is just being clear. Okay. Why would you want to do that? Well, one, you may not trust that healthcare power of attorney would be able to make that decision at that time. It's a very emotional decision. Maybe you've got a spouse, and that spouse would be scared of losing you. And instead of stopping procedures, they continue to do them even though you wouldn't have if you were there. All right. Another main reason that people will do a healthcare directive is they don't want the healthcare power of attorney to have to make that decision. It's a very tough decision to make. And if that living will or medical directive is in place, power of attorney never had to make it. You already did. Okay. Now, this isn't going to be effective unless you're in a coma, persistent vegetative state, persistently unconscious, significant or irreversible brain damage. You're not going to be out mowing the lawn one day, trip over a stick, and she puts you down. Okay. This is only if the doctors realize there's nothing more we can do. We've tried everything, and it's not going to get better, right? It allows you to still be in control of what happens with your treatment.
So one of my biggest questions, and I'm sure a lot of people are thinking the same thing, is like the circumstance where you don't plan ahead. And let's say you have a parent that they're in a coma, they have no planning done at all, and you need to step in and make those decisions. How can you get those documents done when they're already incapacitated?
You end up in court. And that's where you end up being named as a guardian, right? Before we talked about financial powers of attorney, we talked about conservators. The alternate name for an agent for your body through a court process is a guardian. And that court would name you, and then at that point, you'd have the authority to make those types of decisions. Still hard, right? And if you don't go that route, you're going to linger. I mean, the hospital is going to do everything to keep you alive. They're worried about you personally, but they're also worried about their liability, right? There's a lot of lawsuits against doctors and medical institutions, and they have attorneys on staff as well, right? And so they're looking at these documents and determining what authority is given and what can be done when. And their default's going to be to treat. Another question I get about these healthcare directives is, John, is this a DNR, right? Well, first off, a DNR means do not resuscitate, okay? And that's not what these are, right? These are when you're already in a position where nothing more can be done. A DNR is, I don't want to be revived. The only person that can sign a DNR is a doctor. That's a decision that you and the doctor make together. They'll bring out a form and they'll sign it, okay? That way, if something happens in the hospital and you code red or whatever they're calling it, and they're going to revive you, instead they won't, right? They'll let you pass naturally. What this is saying is that you're stable, okay? And there is more treatments we could do, but they're not going to improve anything. They're just going to keep you alive. That's where the living will or the medical directive will say, no, we'll forego those treatments. I'd rather pass naturally. So as you can see with these healthcare power of attorney and this living will, there's some heavy decisions that need to be made. As we've talked about many times on Life's Third Act, it's important to talk to these people, right? First off, make sure that this is a position they want to be in. Second, make sure they understand what you would want them to do, okay? It's going to make it a lot easier on them, and they're going to be able to make the decision with a lot more confidence if they know what you would have done. And that can be through talking directly to them. You know, we all have different ways of communicating. You could write a letter, right? And say everything you need to say in there. And if that's easier for you, I would recommend that, right? Just making sure that they know what you would have wanted done is going to help them make the best decision. Thanks for joining us today on Life's Third Act. We talked about healthcare powers of attorney. Please join us again in the future. We'll continue to answer some of your most pressing questions in relation to estate planning. Speaking of, if you've got a question that we haven't addressed, drop it in the comments. We'd be happy to answer it on a future episode.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.